Right, here we have Unit 5. This is a long chapter. Quite a few questions on the state test will come from this chapter. Real estate brokerages, activities and procedures. This is just a summary of what you'll learn in class. We talk first about brokerage offices. If you are an active broker of record and you have or manage a company, then you must have an office. This office minimum standards are an enclosed room, stationary construction, and you have the privacy to conduct negotiations. Brokers must keep records in the office or have access from that office to online records, including books and real estate transaction files, bank records. And if zoning allows, the office may be in a broker's residence, and you also may have offices in another state. A sales associate may not open up an office of their own in their own name. It has to be in the name of the broker. If the broker wishes to have an office other than the main office, then the broker may need to register a branch office. Branch office registrations are not transferable, and a temporary shelter in the subdivision being sold by a broker is not a branch office unless the sales associates are permanently assigned there or sales transactions and contracts are written and closed at that location. This means a temporary trailer or the use of a garage just to shelter people from the wind and the rain and the sun, and to keep your advertising material would not need to be registered. On your office you must have a sign. Look at this. The minimum 3 pieces on the sign is the real estate company and the name of the broker and the words licensed real estate broker. You must always have this on the sign. This is the only place where this is required, the sign on the front of the office, on the door, on the window. You have to use your trade name if used, and you have to have the broker's name and the words licensed real estate broker. You may put the sales associate and broker associate's names on the entry sign. If you do that, then you must place the names below the names of the brokers, include the license type, whether a sales associate or a broker associate, next to each name, such as sales associate, and to differentiate from the brokers, include a line or a space to separate associate names from broker names. Example given in the book. If you are advertising in any way, shape or form, whether it's classified as your signs or your pens or your giveaways, the very minimum you have to have is always the name of the brokerage firm. If you are advertising as a team, it's very important that you do include somewhere on the advertisement or pages that you are associated with a particular brokerage firm. The team concept allows a broker associates and sales associates to join forces to serve a wider group of customers more efficiently. Teams must advertise in the name of the brokerage firm, and they cannot use specific words as mandated by the National Association of Realtors and now the Florida law with regards to what words you call your team. Blind advertisements. Advertisements that fail to disclose the name of the brokerage firm are called blind advertisements, and for instance only include maybe a PO box or a telephone number and or a street address. Here's an example of a few blind ads. Blind advertising is illegal if that advertising is done by a brokerage or an agent. If the sales associate creates promotional materials, those materials must include the brokerage name, and everything that the agent creates has got to be approved by the broker. If you're using a personal name, licensees may include personal name in ads, must use the last name as registered with FREC when including personal name in an ad. Yard signs, classified ads must include the registered name of the brokerage firm, and licensees may indicate their nickname on business cards and ads, but only if their registered name is also indicated. Here's an example. Call Alfonso, Fonzie, Lombardi. False advertising. Ads of any sort must not contain false, exaggerated or misleading information. It will be a second-degree misdemeanor or $500 and 60 days in jail. A licensee cannot use an association's name or a designation also unless currently a member in good standing. When using your own number, to indicate that by using a mobile or a cell before your number to distinguish it from the office number. In other words, when people see a number, then they automatically assume it is an office number unless you denominate it otherwise. Brokerage telephone number or address does not need to be included, only the brokerage name. Do not use broker on a business card unless you are the broker. Only use broker associate. Internet advertising. When you talk about websites and so forth, the point of contact information is the means to contact the brokerage, the firm or licensing, and must include a mailing address, street address, email address, telephone or fax number. Brokerage name must also appear adjacent or immediately above or below the contact point of information. They want to see more information there when you're dealing with the internet. Association names. Licensees cannot use the term Realtor unless you are an active member of the National Association of Realtors. There will be a $300 fine. Licensees who use the name or designation of an association to lead people to believe the licensee is a member of an association may be found guilty of false advertising. This applies to all designations or letters after your name. Do not use these unless you're qualified to do so. Licensees may sell their own property by owner. They can advertise property and include personal contact information. Brokerage information is not needed. Home mustn't be listed by any brokerage, though. To reduce liability, disclose that the seller is licensed before beginning negotiations and in the contract. So NAI rules do dictate this. Consult employer and broker to see if they allow you to do this. Telephone solicitation. We've all heard about the do not call list. Telephone solicitation is the initiation of a call for the purpose of encouraging the purchase or investment in property, goods or services. Making telephone calls to obtain listings or buyers is telephone solicitation. It is regulated by federal and state law. You're not allowed to call before 8 o'clock and after 9 p.m. if their name is not on the do not call list. If it is on the do not call list, then they cannot be contacted. There are two do not call lists. We have the federal call list maintained by the FCC, and it is a $16,000 fine if you are found guilty of breaking this law. There's no exception for sale by owners, and when added to the Florida list, you automatically get added to the National Registry. Florida law is a no solicitation list, is maintained by the Department of Agriculture and Consumer Services. They have a $10,000 fine. And there is an exception for full sale by owner. You are allowed to call them under Florida law. There are exceptions to the do not call list. When representing a potential buyer, you may call a for sale by owner, seller, provided the buyer is actually interested in the property and may want to see it. You may contact individuals with whom associate has had an established business relationship for up to 18 months. That means you have actually maybe done a sale or found the customer a property. Or if you had a general inquiry, then you may contact that customer by phone for up to 3 months. Companies have to train agents and have policies regarding telemarketing and adherence to the do not call list. Email advertising. There is a thing called the CAN-SPAM Act. Include a valid physical postal address, provide way to opt out of an email, and honor requests within 10 business days. Clearly indicate to the person or the business sending the message, including the domain name and email address and return email address. Faxes are still around. Banks and attorneys still use them, but there is a Junk Fax Prevention Act, which requirements to send fax advertisements, send only with permission. Date and time of the fax is sent has to be included, registered name of the company sending the fax, and a company phone number that sends the fax, and a way to opt out of any more of the faxes. We now go on to a very important segment of this chapter, and this is about escrow or trust accounts. An escrow or trust account is an account for the deposit of money the broker holds in trust for others, such as earnest money, security deposits, first or last month's rent. A deposit is money delivered to a licensee in connection with a real estate transaction. An earnest money deposit can be cash or anything that could be converted into money, such as stocks and bonds. There are acceptable depositories where a broker may open up and hold earnest monies and trust money. For example, you can open up an account in a Florida commercial bank, or a Florida credit union, or a Florida Savings and Loan Association. If the broker does not want to hold his own escrow account, then these monies may be deposited with a Florida-based title company or a Florida broker, in which case the broker is not the escrow agent. When a sales associate receives a check or money from a customer or client with relation to a transaction or rental, then that agent has got to deliver to the employing broker the money no later than the end of the next business day, weekends, public holidays not included. And brokers, they have to deposit into an account no later than the end of the third business day that the company received the money. Broker's time starts after the sales associate or employee of the brokerage receives the deposit. Here's an example. Sales associate received earnest money deposit on Wednesday, therefore she has to get it to the broker on Thursday, no later than Thursday, and the broker must deposit the escrow account no later than Monday. So we have Wednesday, then we have Thursday, Friday, not Saturday or Sunday, then Monday. And here's a quick example again. Put in pictorial form, sales associate received earnest money on Wednesday and must deliver the deposit no later than Thursday, and a broker must end up depositing it into the escrow account no later than Monday. If an agent should actually receive an earnest money check or any check payable to the agent personally, then she should actually give it back and have the buyer or the renter write a new check. So always instruct a buyer to write a check payable to the broker's escrow account, and if not practical, then you can write on the back of it to deposit only and endorsed over to the name of the escrow account, and photocopy the check and endorsement for your records. Post-dated checks and insufficient funds. First of all, you can, as a broker, accept a post-dated check, but you have to get both permission from the buyer and from the seller and the buyer, obviously. Obtain the seller's approval before accepting. Broker must secure check until payable and then immediately deposit when it becomes current. If the check is bounced for insufficient funds, the broker is not held responsible as long as the broker made a timely deposit according to the law. Signatories on the broker-held escrow accounts. At least one of the brokers, if there's only one, then his signature must be a signatory on the escrow account. Additional persons, such as a bookkeeper, may also be a signatory. Escrow accounts must be reconciled every month, and the broker must review, sign, and date that monthly reconciliation. Interest-bearing accounts. You can hold the monies in an interest-bearing account, interest-bearing escrow account. Written permission from all parties, though, before placing in an interest-bearing account is needed. And written authorization must also include who is entitled to the interest earned. And also the broker, if authorized by both sides, may receive some or part of the interest earned. Misappropriation of escrowed funds. It is a big no-no. You will get into serious trouble, either as a broker or as an agent. Do not commingle. Mixing escrow funds with office or personal funds is called commingling. When actually using other people's funds for your own use, this is called conversion. Another big no-no. If you want to open up your own escrow account as a broker, then you may place up to $1,000 of personal brokerage funds into a sales escrow account. If you're opening up a property management escrow account, you may place up to $5,000 of personal brokerage funds into that account. If you deal with sales and rentals, you don't have to have both accounts, but it is easier to separate them. Brokers must keep all records, books, accounts in compliance with and available for DPPR audit. must preserve records for 5 years and 2 years beyond a court proceeding. Note, the 5 years and the 2 years apply to all brokerage record keeping, anything that has a signature on it, or anything that is legally connected with a contract or a listing. Here's an example from the Florida Disciplinary Activity Reports of 2016, I think this was, and the items highlighted in orange indicate exactly, out of all the cases, which ones were associated with misuse of escrow funds. As if you are not keeping your own escrow account but keeping it with a title company or an attorney, here's some rules here. You have to indicate on the contract which attorney or name and address of the title company is being used. Within 10 business days after the deposit is due, then the brokers must make a written request to the title company for verification of receipt of the deposit, that the check has been cleared okay. And then within 10 business days after the broker has made that request, the title company must provide the seller or the agent with a copy of written verification. If not provided, the broker must inform of such the seller's agent or the seller. This is a place on the contract where we would put the agent holding the escrow money. Sometimes more than one deposit is needed. Treat as separate deposits. Use the same rules, 1 + 3 days. If there is any dispute over escrow monies held in broker's account, in other words, if the contract falls to pieces and the buyer wants the money back and the seller wants the money, then if we can't come to some mutual agreement about who gets what, then the broker, by law, must notify FREC within 15 business days. If money is held in a title company or an attorney account, then the parties must go there to settle. The broker is not involved in the dispute. The broker must not disburse escrow funds until transaction closes or with an agreement of the parties, with exceptions. When dispute arises, a broker has what is called conflicting demands, when the buyer and the seller make demands regarding disbursing of escrow funds that are inconsistent with each other and cannot be resolved. So the broker must notify FREC in writing within 15 business days of receiving conflicting demands, and then begin settlement procedures within 30 days of receiving conflicting demands. The time periods run concurrently. Here's an example of a form which you can use to notify DPPR and FREC of the conflicting demands. We have a procedure which we can use within that 30 days. We have to start one of these as the broker. It doesn't have to be in this order, we just put them in this order for ease of remembering. We can ask the parties go to mediation, which is an informal, neutral party negotiated settlement, must be completed within 90 days from the first conflicting demands. Arbitration. Binding judgment by a third party, usually an administrative law judge, does need prior consent of the parties. We can get their lawyers to take everybody to court and start suing each other, in which case that's litigation. And we have two types of litigation. Interpleader, when the broker has no financial claim, the broker just hands over the funds to the clerk of the court, and then the parties argue with the judge. Or there's a declaratory judgment, when the broker does have some rights to some of the escrow money as per the contract, therefore the judge will then declare each party's rights to the funds. Or we can actually go and notify FREC in writing that we have a request for an escrow disbursement order. Note, the above only applies when the funds are held in broker's own escrow account, not if it is held in a title company or an attorney. FREC will not be interested in that. You have to send the parties themselves with their lawyers off to either the title company or the attorney. An escrow disbursement order is when the Commission will issue a determination, if they are willing to do it, of who is entitled to the disputed funds. Funds must be held in a brokerage escrow account, not in a title company or an attorney. The broker must inform FREC within 10 business days, though, if the dispute is settled or it's decided to go to court. And the request is for no more than $50,000. This is a request for an escrow disbursement order. Exceptions and notice settlement procedures to the notice and settlement procedures. For instance, brokers are not required to notify FREC or start a settlement procedure in these situations. If you're dealing with a sale of a HUD-owned property, then you look to the HUD contract to determine exactly how to handle the escrow funds. If there is a legal timely notice to cancel a residential condominium contract, we cover that later on in the chapters. Also, failure to satisfy a financing clause in the sales contract. That means the buyer doesn't qualify or the home doesn't qualify to get a loan. And also, not in the book, but I've just added it here, a dispute over security deposits or last month's rent when dealing with a tenant moving out of a rental. The same as conflicting demands, except it hasn't actually occurred, but the broker has good faith doubt that the transaction is not going to close. Broker doubts either party's intention to act in good faith according to the contract. So he has to notify FREC in writing within 15 business days of having the doubt, begin a settlement procedure within 30 business days of having that doubt. And once again, the above is only for when the funds are in a brokerage escrow account. Also, if you have any advance fees for work you have not yet performed, these must be placed in an escrow account, but you cannot charge an upfront fee for a listing timeshare. If you as a property manager or broker sell rental information and lists, therefore you'll be subject to these laws. First of all, when you sell a list to a potential tenant looking for a rental, then the written disclosure is required, and on this written disclosure it will state that if the rental information provided under contract is not current or accurate, the consumer may demand orally or in writing within 30 days of the contract date 100% return of the fee paid. If, though, the list is good, but the consumer just doesn't happen to obtain a rental, then the renter is entitled to receive a return of 75% of the fee paid if demand is made within 30 days of the contract date. If you do sell inaccurate information and it's not current, this is a first-degree misdemeanor, $1,000 or 1 year in jail. Rental receipt with rules must be used and a copy to DPPR within the first 30 days of first use. We're talking now about sales associates commission. Just remember that everything that is paid is always paid to the broker first and then split with the sales associate or broker associate. So it must be paid by associate's employer, not ever directly by the buyer or the seller. The sales associate split is determined by agreement with the employer, and sales associates may not operate independently. Everything has got to be done in the name of the broker. All listings, contracts, commissions are legally the property of the sales associate's employing broker. The broker's commission continued. Remember, you can never be paid directly by the client or customer. All payments go first to the broker and belong to the broker. This is established by agreement between the broker and the party who agrees to pay. Negotiable with the buyer or the seller or the tenant or the owner, and then the broker will split what the broker gets with the agent, and that's negotiable. State of Florida does not regulate commission rates or fees, and licensees may share their commission with the buyer or the seller in that transaction as long as both parties agree to it. This is if you want to give a rebate or a discount to your customer. There are antitrust laws. Antitrust laws basically is to protect competition and ensure against restraint of trade by brokers colluding together to fix prices or fix locations. There is the Sherman and Clayton Antitrust Acts and the Federal Trade Commission Act. It is illegal to fix commissions or fees for services. Brokers can't collude together and say, I'll charge this amount as long as you charge this amount. We can also not conspire to split up market areas to avoid competition. Brokers can't say, you work on this side of the river and I'll work on that side of the river. There's another little paragraph here about liens on real property for unpaid sales commission. This is a rule which goes back to page 16, which is part of 475. You cannot alienate a right to take possession of a property belonging to another unless that person, until a debt owed by that person is discharged. So a lien is a right. I said alien. A lien is a right, a document filed with the court has. So only brokers can seek compensation from buyers or sellers, not the agent. The agent is owed the money by the broker. Liens on residential property for non-payment of commission, only if the broker is given that authority in a listing contract, otherwise to seek civil judgment, and may not encumber title to the real property. Part 3 deals with the Commercial Real Estate Sales and Lien Act and gives broker lien rights on seller's net proceeds from the sale of the property, but it's not a lien on the actual real property itself, and brokerage agreement listing contract must clearly state the broker's lien rights. Part 4 is the Commercial Real Estate Sales Commission Lien Act. It gives broker lien rights for the commission earned for leasing commercial real estate. If the landlord agreed to pay the commission, lien is against the landlord's interest in the real property. If the tenant agreed to pay the commission, then the lien is on the tenant's leasehold estate. Agents and brokers are not allowed to organize, offer, or receive kickbacks under most circumstances. These are referral fees for non-real estate services. The buyer and the seller must be fully informed if you are accepting one, which is legal. Must not violate RESPA, which is illegal for closing services, title searches, appraisals, and so forth. And the person receiving kickback must be properly licensed if applicable. For instance, a mortgage loan officer with a license. Licensees may share their commission with the buyer or the seller in that transaction, but they may not share commission with any other unlicensed person. May not pay an unlicensed person for a referral fee for a real estate business, other than an apartment manager or owner may pay a finder's fee of up to $50 to a tenant to find another renter for one of the units. We look to see which entities can register a brokerage as a business. 475 defines a broker to include anyone who is a general partner or an officer or a director of a partnership or a corporation. 475 prohibits a person licensed as a sales associate or a broker associate from registering as a general partner or an officer or a director of a brokerage entity. So you do have to be a broker who is an officer of the company, not just one who is employed by and works under a broker. We've got 6 entities that may actually register as a brokerage. Sole proprietorship, general partner, limited liability partnership, and corporation and a limited liability company. Sole proprietorship. This is just owned by one person. The owner is totally liable for all the debts. The owner must have an active broker's license, may register under his own name or a trade name, and does not have to file articles with the state to form the entity. A general partnership. 2 or more persons engaged in business together, can be created written or oral or by an implied agreement. Each is liable for partnership debts and can bind the others. This one also does not have to register with the state. Registered partnership with the DPR not needed for the state. Real estate brokerage general partnership. At least one partner must be an active broker in a partnership. Partners who deal with the public and perform real estate services must also be active brokers. Sales associates may not be general partners. If the only broker dies or resigns, then you've got 14 days to find another. Limited partnership is created by a written instrument filed with the Florida Department of State on sunbiz.org. 1 or more general partners and 1 or more limited partners are needed, and limited partners may make investment of cash or property, but not of services as an officer or a director of the company. But limited partners will have limited liability, unlike the general partners will absorb or the liability for all debts. To become a brokerage with a limited partnership, you have to register the partnership with the DPPR. Once again, general partners who perform real estate services must be active brokers. At least one general partner must be an active broker. All other general partners, if not even with a brokerage, then they have to register with the DPPR for identification purposes. And sales associates may not be general partners. Limited partners do not need to register with the DPPR. A lot of information there. Ostensible partnerships are prohibited. This means when it looks like you may be working with someone else as a partnership but you're not, then you could get into trouble. Quasi-partnership is called. When the actions of two or more persons create an appearance that a partnership exists, each then may end up being liable for each other person's debts and torts according to a judge, and you may even have your license suspended. A limited liability partnership, very similar to a general partnership, but it does have to be registered with the state. And protection of personal liability, partners are not subject to the limitations imposed on limited partners in a traditional limited partnership. Don't worry too much about this. The name of the registered limited liability partnership must include in the name the registered limited liability partnership, or LLP, at the end of the name. Corporations, an artificial person or legal entity created by law. File articles of incorporation with the Florida Department of State. If a foreign corporation is organized under another state, may still do business in Florida though. A domestic corporation is one that has been incorporated in Florida and is managed by a board of directors and officers, and of course is owned by the shareholders, maybe profit or non-profit. To become a brokerage, you have to register with DPPR. At least one officer or director must be an active broker. Active and inactive brokers and unlicensed people may serve as officers and directors. Must be active broker though to perform real estate services with the public. Unlicensed officers and directors register with the DPPR. Sales associate may not be an officer or a director, but the sales associate may be a shareholder. An LLC. This features the best of a corporation and a partnership. The persons are protected from personal liability, and the IRS treats an LLC as a partnership for tax purposes, and income is only taxed once, as in a partnership. If the only active broker of a brokerage entity dies, resigns, or is incapacitated, the vacancy must be filled within 14 calendar days. No new brokerage business may be conducted until a new active broker is registered with the DPPR, and failure to timely replace a broker results in cancellation or of the registration, and the license becomes involuntary inactive. The vacancy of office may be filled with a temporary broker. That broker must be registered with the DPPR, and this is allowed for up to 60 days without the need for that broker to be registered with the Secretary of State under sunbiz.org. Failure to appoint an active or temporary broker within the 14-day deadline will result in the automatic cancellation of the brokerage's DPPR registration. We have business entities that may not register as a brokerage. A corporation sole, which is a church or an ecclesiastical or religious organization. A joint venture, temporary business arrangement, cannot register as a brokerage. There will probably be two or more separately registered brokers may conduct real estate business as a joint venture. A business trust is when a group of people get together, put money into the kitty to buy property. If it involves its own property, then they can buy and sell it, but they cannot register as a business brokerage. A co-op involves its own property. They can buy and sell their own property, but they cannot register as a brokerage. And also an unincorporated association, for example, of property owners in a subdivision or an HOA and co-op. You may register under a fictitious or trade name. This is a business name other than the legal name of a person doing business. Sometimes we call it trading as or doing business as. The fictitious name refers to the name registered with the Department of State, and brokers who operate under a trade name must also register that trade name with the DPPR. Associates must have licenses issued in their legal names, not under a trade name. And if you're performing a professional association in associate's legal name, this is an example of a PA or an LLC. Sales associates and broker associates may organize themselves in a type of professional association in their legal name for tax purposes. Example, Sally Smith PA is a sales associate. Bob Brown LLC is a broker associate. That becomes their official name, and that's what will be on their license, and that's how their checks will be made out. DPPR license must be issued in the licensee's legal name, including the professional designation. And finally, personal assistance. When you start getting busy, you'll find that you would like to employ a personal assistant to do a lot of the unlicensed activities. So if the personal assistant is unlicensed, there is a described set of tasks which are allowed, which is in the book. But they perform administrative tasks. They may not perform duties requiring a license, may not be paid a commission, only a salary, and the licensee who employs unlicensed assistants must comply with the state and federal employment laws. Licensed assistants, though, can perform the services of real estate, must be registered with the employing broker, and broker must pay licensed assistant for brokerage activities. And that is the end of Chapter 5. There's a lot going on in there, and you'll probably need to reread it a few times and do lots of questions on it. Go now, if you've already done this in class, and this is a recap, go through the questions at the end of the unit in the book. Thank you very much.